Senate will come back to order. The Senate will come back to order. Chair recognizes the senator from the 18th for a motion. So quiet in here.
Thank you, Mr. President. I ask for unanimous consent that HB 502 be taken from the table.
Mr. Secretary, please read the caption of House Bill 502.
House Bill 502 by Representatives Welch of the 110th and others. The bill will be titled Enactment Article 7 of Chapter 10 of Title 9 and Article 2 of Chapter 8 of Title 17 of the OCGA relating to continuances, so as revised continuances for members of the Board of Regents and the Attorney General and for other purposes. Mr. President, the Senate Rules Committee offers the following substitute to House Bill 502. The bill will be titled Enactment Article 7 of Chapter 10 of Title 9 and Article 2 of Chapter 8 of Title 17 of the OCGA relating to continuances relative to civil practice and procedure and continuances relative to trial, respectively, so as to provide for and revise the granting of continuance and stays in civil and criminal cases at certain times and intervals for members and certain staff of the General Assembly for purposes of fulfilling their responsibilities to the General Assembly for other purposes. Amendment 1 by Senator Dolezal of the 27th and the others offers the following amendment and amend the Senate Rules Committee substitute to House Bill 502 by deleting everything after the word meeting on lines 105 through the word assembly on line 107. Mr. President, that concludes the order.
Senator from the 18th has asked for unanimous consent that House Bill 502 be taken from the table. Is there objection? Chair hears none, and House Bill 502 is taken from the table. Chair recognizes the senator from the 6th to speak to 18th. Change of course. Chair recognizes the senator from the 18th to speak to House Bill 502.
Thank you, Mr. President, and good evening, colleagues. You know, the duties of a legislator extend far beyond session. The 40 days that we're here, as they say, the 40 days and 80 nights. And I don't have to look too far around this room to see folks that I know that are hard-working legislators, very dedicated. And you all know that when you go back home, sometimes that's when the work begins. Lawyers have an added challenge in that we have others that control our schedule. And the court system, especially attorneys who litigate in the courts of our state, largely have their calendars determined by judges, determined by trial calendars, determined by hearing calendars. And so because of that, fortunately, the law recognizes that attorneys who serve in the legislature get what's called legislative leave. This also helps ensure that we do have attorneys that serve. And it simply provides us a way of being able to manage our calendars and also know what our schedules will be. There have been some recent suggestions that perhaps we need to revisit exactly how legislative leave is enacted and the breadth of that. And that's what HB 502 does. There are two principal sections, Section 1 and Section 3. I want to go through those with you and tell you exactly what these proposals are for changing the current law. Section 1 deals with Title 9, which is the Civil Practice Act. That is, deals with cases coming between two litigants, a plaintiff and a defendant. And Section A is amended in lines 16 through 19, in where the members of our legislative council are added to this for protection. That's because some of these attorneys actually handle matters outside what they do for us at the Capitol. And while they're here, I don't think I have to work hard to persuade you that we need them here during this time. And so this simply allows protection for the time that they're serving us. Going on further into Section 1, and this is one of the significant changes, lines 37 through lines 40 is the removal, and this importantly removes the discretionary time that attorneys have to have leave when the attorney certifies that their presence is required beyond the duties of the General Assembly. The current law provides that we get protection from the time of session plus 3 weeks, and then other certain circumstances, one of which is sort of a broad-based time and a broad brush approach, which says that any time the attorney certifies that their presence is required elsewhere based on their duties of the General Assembly. And so this bill strikes that portion, lines 37 through 39. It adds, as you will see in lines 32, 33, and 34, a few things, but they're specific. It's not something that the lawyer has a lot of discretion in, or really any discretion, with regard to those. It does four things. When the attorneys would have protection for times for a legislative committee that's you're working on. Number two, anytime an attorney is and a member of this body or this legislature is attending a national legislative conference, also a caucus meeting, or also a study committee. Those are times that you would that the attorney would get protection. If you move on down to line 44, the section B, this is a new proposal, and this provides that an attorney may request, but there's not an automatic granting of a continuance for other times. And I think it's a very well-balanced model, because what in essence it says in the new provision is that if the attorney applies, it doesn't automatically mean that that leave or that protection is granted. But first of all, they must request it. Second of all, opposing counsel or the other party or the court can object. And then the bill sets forth the metrics in which the judge ought to determine whether or not the attorney has that time off or has protection from being called to court duty. Let me move on to section 3, beginning at line 78. This is a little different. There's a few differences in how we treat. This comes from Title 17, which is the criminal code. As was related in lines 16 through 19, we're also providing the Office of Legislative Counsel for those lawyers that serve us here in the legislature. We're giving them their protection. And then moving on to the rest of the bill toward the bottom of section 3, you'll see there's a slightly different metric. Similarly, the language for the automatic granting is removed from this section, but you'll see that there's a different person added here that can object, and that's the victim of the criminal case. When the request is filed, if you're in section B, beyond the times that the law says you get protection, then number one, it's not automatically granted. But number two, the opposing counsel can object, the court can object, and the underlying victim in the criminal case can object and ask the court to not allow that continuance. That's one of the main primary differences between the two sections in the civil and the criminal. Finally, I understand there's one amendment which deletes lines 105, 106, and part of lines 107. This removes from the criminal section the time for an attorney to get protection for attending the conference, the board meeting, the caucus meeting, and the study committee meeting. So the removal of that language by amendment number 1 further tightens down the times and opportunities that an attorney is entitled to have legislative leave. Mr. President, I'm happy to answer any questions or further explain any of the provisions, but I would urge your support for this modification of one of the laws that we have on our books that, quite frankly, enables lawyers to come down here to the Capitol and do the service like many of you do when you leave your businesses and serve the people of Georgia. I'm happy to answer any questions, or I'll yield the well.
You have a question. Chair would like to recognize the senator from the 48th for a question.
Thank you, Mr. President. Does the senator yield?
I'm happy to yield to my friend from Gwinnett.
Thank you, sir. Isn't it true that we as attorneys are officers of the court, such that if we make representations to the court that we're needed to be somewhere, we should be telling the truth to the court?
Yes, I would agree with that, Senator. We are officers of the court, yes.
And so I'm somewhat concerned about laying out specific times that you might need to be able to be away from the court, rather than saying the attorney has to petition the court for whatever reason we might have to be away, rather than enumerating what we have enumerated here, for example, in lines 34 through 37.
I'm sorry, Senator, was there a question? I didn't gather a
Yes, sir.
question there.
Yes, sir, I apologize. It's
apologize for not recognizing the
It's
question.
8:17 PM, so let me try that again.
Sure, that's all right.
So my question is, then, given that I'm an officer of the court and I'm supposed to be representing the truth to the court, why is it needed to be enumerated some specific things when I might need to miss court for something that is indeed not specified here, but is something that I need to do with my legislative duties, and thus I need leave of court?
Senator, I appreciate the question, and I think to answer that question, I think there's large consensus that we ought to take a look back at this provision that allows us the privilege of this. And I think most people that looked at it realize perhaps there's a little too much discretion that we attorneys are given. And so if we're going to set up the structure of this model where you've got two categories of leave, in essence, you've got those in which you're guaranteed leave, which is the subsection A,
Okay.
and then you've got the discretionary part, which is subsection B. If, in fact, I think if I understand your question and the source of your concern, anything we add to subsection A is going to give you that additional protection.
Gotcha.
Subsection B allows you to always petition the court.
Gotcha.
It's just not going to be automatic.
Gotcha. And then, does the senator yield?
Certainly will.
So then, as to the criminal aspect, and I practice civil and criminal, so I just want to make sure I'm clear the difference between what we're proposing for criminal lawyers versus civil lawyers.
Sure. You want me to go back over that with you again?
Yes, sir, if you don't mind.
Okay, sure. The difference is that based upon, if amendment number 1 passes, then lines 105 through 107 would be removed so that a lawyer in a criminal case would not have the protection automatically granted, or that would be mandatorily granted in attending a national conference, a caucus meeting, a study committee, or whatever the fourth one was.
It's okay.
Yeah.
I
So
got you.
those four. That's one difference. And the other difference is under the model for the civil cases, the people that can object, if in fact you file your legislative leave, instead of it being under the civil section, the opposing counsel, the party, or the court. In a criminal matter, it is the opposing counsel, the victim, and the court.
Great,
I think
just so
that
I'm
really
clear.
are the differences.
So just to be clear, Senator, then we are making sure that a victim in a criminal case has the opportunity to object if the calendar is putting off the trial for too long.
That's exactly right. Is we want that victim, based on this legislation, to have an opportunity to come forward, and the court will listen to them and have to hear their concerns about any further delays of their case.
Yes, sir, and I appreciate that. As a former federal prosecutor, I definitely want victims to have their voices heard and to make sure that this is not abused. I appreciate us adding that clarification.
You're welcome. Thank you. I appreciate your questions, and thankfully this also does not have a fiscal impact.
Chair recognizes the senator from the 27th for a question.
Thank you, Mr. President. Senator Yield, for a couple of questions.
Sure, I'd be happy to. Thank you.
Thank you, Senator. You were speaking about this as it relates to lawyers, but isn't it true that that protection actually is in place for all members of this body and the House, such that if I were party to a civil or criminal suit as a defendant, I would be able to take legislative leave to prevent having to give a deposition or something that would relate to appearing in court such that I could fulfill my duties here. Is that not correct?
It is correct, Senator, and I appreciate that distinction, and I probably should have gone into that. Forgive me. I was thinking more of the impact on lawyers and the effect it'll have on us that practice, but that's a great point. It's not just a privilege for lawyers. It really is to recognize the service that the people in this body and the people across the hall that come here as citizen legislators, and in the event that they are either voluntarily or involuntarily pulled into the court system, or if you practice there professionally, you have the protection against those deadlines and being able to compel to attend some sort of court-related event during the time you're here serving. Thank you.
Do you further yield?
I do.
From my understanding, this law goes all the way back to 1905 or even earlier. And as a student of the law yourself, could you help illuminate how this would help with the separation of powers, and where while we're in legislative session, we have the ability to change legally what the court may or may not be able to do. So is the genesis of this really to make sure that the judges cannot leverage power over legislators by hauling them into court while we're in session? Should we be considering legislation that may impact the bench or the judicial branch in general?
Thank you, Senator, and that's an interesting approach, and you're absolutely correct. It does relate to the balance of powers between the different branches. So it's not just a matter of ensuring that attorneys and others of us that may be involved in a court process are able to have protection against others scheduling things involuntarily over on top of us, so to speak. But there's also the concern that you raised, and I appreciate that point, yes.
Thank you. Do you further yield?
I do.
Can you talk one more time about the change between the existing law and what you're proposing here as it relates to requests for legislative leave outside of session? Is it true that the current law allows for a carte blanche statement stating that I have legislative duties that are keeping me busy elsewhere, therefore I could not appear in court, and what you have here in your bill requires I believe the word was particularity, which I'd never heard before, but a particular specified definition or explanation of where I'm going to be. Can you walk us through that, please?
Sure, I'll be happy to. And specifically, and I think this is the biggest change in the bill, and I think this is the biggest indicia of the recognition that we need to have a slight course correction with regard to legislative leave, and that's found at lines 37 through lines 40. What's currently in the law and what would give one of us protection says, a continuance and stay shall be granted for other times as the member of the General Assembly or staff member certifies to the court that his or her presence elsewhere is required by his or her duties with the General Assembly. Obviously, that leaves a lot of broad discretion to the person utilizing that section. That is stricken so that that section, that sort of catch-all provision, would not be, if this bill passes, would not be a part of the legislative leave going forward.
Thank you. Do you further yield?
I do.
So taking the lawyers out of it, take a small business owner, for example, and let's knock on wood it doesn't happen, but pretend I'm being sued for something. Under the current law, I can just say that my legislative duties require me to be elsewhere. I don't need to state what I'm doing or what I'm going to be, where I'm going to be. Under your law, I'm essentially asking permission. So last question, can you walk us through, is it true that the existing law is a shall be dismissed or shall have state leave from court, and what you're proposing here is a may that is contingent on approval by the court? Is that true?
Yes, that is absolutely true. The shall language is found at lines 37 that says the continuance and stay shall also be granted. And we're pivoting from that shall language, and the mandatory granting of the protection is replaced rather with section B1, which begins at lines 44 and speaks to when a request is made by a member of the General Assembly. And here's the critical difference, Senator. On line 46, it says to a case may request a continuance. So that's the operative language. Those are the critical differences, and I think you've done a good job of pointing out and helping me point out the differences on where the law is now, where it needs to go, and why we need to be there.
Thank you, Senator.
Thank you. I appreciate the questions. Mr. President, if no further questions, I'll yield the well.
You have no questions. Does any other senator wish to speak to the bill or the amendments? Chair recognizes the senator from the 27th to speak to his amendment.
Thank you, Mr. President. I believe the senator actually did a fantastic job of outlining this amendment. It is quite simple. It is striking and limiting the ability when we are outside of session for what we may request leave for. So in the criminal section, it is removing our ability to request leave for a national legislative conference or board meeting, a caucus meeting, or a meeting of a study committee. And Mr. President, if there's no further questions or any questions, I'll yield the well.
You have no questions.
Thank you.
Chair recognizes the senator from the 6th to speak to her amendment number 2. Chair recognizes the senator from the 6th to speak to amendment number 2. What purpose does the senator from the 6th rise?
Do I need to formally make a motion to withdraw my amendment number 2?
Senator from the 6th has made a motion to withdraw amendment number 2. Is there objection? Amendment number 2 is withdrawn. All right, let's take up amendment number 1. The question is on the adoption of amendment number 1. Is there objection to adoption of the amendment? Chair hears none, and the floor amendment is adopted. The question now is on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none. The committee substitute is adopted as amended. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 3rd for a motion.
Thank you, Mr. President. I ask for unanimous consent that House Bill 470 be taken from the table.
Mr. Secretary, please read the caption.
House Bill 470 by Representative Sains of the 180th and others, a bill be titled enactment Article 6A of Chapter 3 of Title 35 of the OCGA related to DNA sampling, collection, and analysis was provided for analysis and collection of DNA for individuals charged with a felony offense but sentenced as a first offender or under conditional discharge and for other purposes. Mr. President, the Senate Committee on Judiciary offers the following substitute to House Bill 470. Bill will be titled enactment Chapter 6A of Chapter 3 of Title 35 of the OCGA related DNA sampling, collection, and analysis so as to provide for analysis and collection of DNA for individuals charged with a felony offense but sentenced as a first offender or under conditional discharge and for other purposes. That concludes the order.
Senator from the 3rd has asked for unanimous consent that House Bill 470 be taken from the table. Is there objection? Chair hears none, and HB 470 is taken from the table. Chair recognizes the senator from the 3rd to speak to House Bill 470.
Thank you, Mr. President. Our Criminal Justice Reform Act passed in 2016 inadvertently removed the requirement that defendants who were for felony offenders who were given the first offender status not be required to provide a DNA sample. And as a result of that, because they're not under that obligation, this bill corrects that and puts them back under that obligation of the law. Now, it's important that we do this because for the last 2 years, in some instances, those samples were taken, and after they were run through the FBI databases, there were 102 matches. So it's important that we correct this and once again require those who are on first offender for felony charges be submitted to those tests. So, Mr. President, I'll be glad to answer any questions.
You have no questions.
Yeah, I yield the will.
Does any other senator wish to speak for or against the bill? Chair hears none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass by substitute? Question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 48, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 50th for a motion.
Mr. President, I move that the Senate agree to the House substitute to Senate Bill 171.
Ms. Secretary, please read the caption.
Senate Bill 171 by Senator Wilkinson of the 50th and others. A bill will be titled enactment Title 15, Chapter 2 of Title 21, and Chapter 5 of Title 48 of the OCGA relating to courts, primaries, and elections generally, and ad valorem taxation of property, respectively, so as to modify the compensation of various local government officials and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 171. A bill will be titled enactment Chapter 3 of Title 1, Title 15, Chapter 2 of Title 21, and Title 48 of the OCGA relating to laws and statutes, courts, elections, and primaries generally, and revenue and taxation, respectively, so as to modify certain provisions regarding the compensation received by certain local government officials and other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 50th to speak to his motion.
Thank you, Mr. President. Members of the Senate, Senate Bill 171 is a bill that increases the minimum salaries for our clerk of courts, tax commissioners, sheriffs, and probate court judges. If you'll remember, when we passed this bill 51-1, we changed the implementation date to January the 1st, 2021. That would not give anyone a pay raise during their current term, and it would mean that the newly elected officials would receive the pay raise. There were some technical changes, as you'll notice in here, that had to do with the census, when the census is taken. For clarification, just some minor changes, so I urge you to support this legislation. If there are no questions, I'll yield the well.
You have no questions.
Thank you.
Any other senator wish to speak for or against the motion? The chair hears none. The senator from the 50th has moved that the Senate agree to the House substitute to Senate Bill 171. All those in favor vote yea, opposed nay. The secretary will unlock the machine. On the motion, the yeas are 47, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 171. Chair recognizes the senator from the 33rd.
Thank you, Mr. President. I move that the Senate agree to the House amendment to the Senate substitute to HB 79.
Ms. Secretary, can you please read the caption?
House Bill 79 by Representative Gilliard of the 162nd and others. The bill be titled enactment Chapter 4 of Title 30 of the OCGA relating to rights of persons with disabilities so as to provide that blind persons shall not be discriminated against by the courts, Department of Human Services, or a child placing agency in matters relating to child custody, guardianship, foster care, visitation, placement, or adoption, and for other purposes. Mr. President, the Senate offers the following substitute to House Bill 79. The bill will be titled enactment Chapter 4 of Title 30 of the OCGA relating to rights of persons with disabilities so as to provide that blind persons shall not be discriminated against by the courts, Department of Human Services, or a child placing agency in matters relating to child custody, guardianship, foster care, visitation, placement, or adoption for other purposes. Mr. President, the House offers the following amendment. Amend the Senate Committee on Judiciary substitute to House Bill 79 by replacing blind with legally blind on lines 2, 7, 36, 37, 38, 42, and 52, and for other purposes. That concludes the order.
Chair recognizes the senator from the 33rd to speak to his motion.
Thank you, Mr. President, my fellow senators, colleagues, friends, and y'all. This is just a cleanup bill. It deals with the rights of legally blind people in child custody. All it did was change blind to legally blind, and it also put it in accordance as how it's defined by the Department of Human Services. And then it also brought it up to federal codes. Senator from the 48th, there is no fiscal note. However, I thought about you last evening. My girlfriend asked me for $100, and I asked her, did she have a fiscal note? Now I'm in the doghouse. Mr. President, I yield the well.
Senator has yielded the well. Does any other senators wish to speak for or against the motion? Chair hears none. The senator from the 33rd has moved that the Senate agree. For what purpose does the senator from the 48th rise?
Parliamentary inquiry.
State your inquiry.
I believe the young lady's handing out the copies of this bill. Can we have time to see that? Is that this?
Absolutely. We'll give time for the amendment to be handed out. Absolutely. Senate will stand at ease for 2 minutes. All right. Everyone should have a copy. Does any other senator wish to speak for or against the motion? The chair hears none. Senator from the 33rd has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 79. All those in favor, vote yea. Opposed, nay. The Secretary will unlock the machine. On the motion, the yeas are 49, the nays are 1, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 79. Chair recognizes the senator from the 42nd for a motion.
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to HB 478.
Ms. Secretary, please read the caption.
House Bill 478 by Representatives Ballinger the 23rd, the bill with title enactment in Article 8 of Chapter 5 of Title 49 of the OCGA relating to the Central Child Abuse Registry so as to provide improvements to the operation of the Child Abuse Registry and for other purposes. Mr. President, the Senate offers the following substitute to House Bill 478, a bill be titled enactment in Article 8 of Chapter 5 of Title 49 of the OCGA relating to the Central Child Abuse Registry so as to provide improvements to the operation of the Child Abuse Registry and for other purposes. Mr. President, the House offers the following amendment, amend the Senate Committee substitute to House Bill 478 by inserting after matters on line 5 to provide for an effective date and for other purposes. That concludes the order.
Chair recognizes the senator from the 42nd to speak to her motion.
Thank you, Mr. President. Colleagues, this is the Child Abuse Registry bill that I presented a couple days ago. There was unfortunately an error in line 169 when talking about the evidence presented as to whether an individual should remain or be removed from the Child Abuse Registry. The word not should not have appeared there, otherwise it threw the standard off. This legislation has been worked on by GACTL, Prosecuting Attorneys Council, the Barton Center at Emory University, and would appreciate your agreement to fix this small error. I'm happy to answer any questions if there are any.
You have no questions.
Thank you.
Any other senator wish to speak for or against the motion? The chair hears none. The senator from the 42nd has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 478. All those in favor vote yea, opposed nay. The secretary will unlock the machine. On the motion, the yeas are 49, the nays are 0, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 478. Chair recognizes the senator from the 20th for a motion.
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to House Bill 512.
Ms. Secretary, please read the caption.
House Bill 512 by Representative Watson, the 172nd, and others. A bill will be titled enacted in Chapter 8 of Title 2 of the OCGA relating to agricultural commodities promotion so as to provide for an agricultural commodity commission for propane and for other purposes. Mr. President, the Senate offers the following substitute to House Bill 512. A bill will be titled enacted in Chapter 8 of Title 2 of the OCGA relating to agricultural commodities promotion so as to provide for an agricultural commodity commission for propane and for other purposes. Mr. President, the House offers the following amendment. Amend the substitute to House Bill 512 by striking Chapter 8 of on line 1 by striking agricultural commodities promotion and for other purposes. That concludes the order.
Chair recognizes the senator from the 20th to speak to his motion.
Thank you, Mr. President. Good evening, colleagues. House Bill 512 in its original iteration creates the Agricultural Commodity Commission for propane, allows them to have a checkoff program and market and educate related to propane. The House has decided to add a whole nother several more sections to try to address some concerns several of us have with the application of industrial byproducts as fertilizer on land. So that's what the amendment does. If you've got it in front of you, if you just kind of go through it with me. Line 8 through 18 defines fertilizer, and line 16 through 18 says it does not apply to material for which the distributor compensates by any means the property owner or property custodian which is receiving the material. In other words, the distributor of this stuff is paying the landowner to allow them to apply it or dump it on their property. So that's not contemplated here. Lines or sections 4, 5, and 6 gives the Commissioner of Agriculture the authority to promulgate and adopt rules and regulations relative to fertilizers derived from industrial byproducts. And I think this is a good measure to try to get a handle on some of these practices that are causing concerns environmentally and odor and otherwise in some of our communities. And I'd be happy to answer any questions, and if there are no questions, I ask for your favorable consent to this.
Chair recognizes our good friend from Gwinnett County.
Thank you, Mr. President. Does the Vice Chairman yield?
Yes, ma'am.
I wanted to ask, you said lines 16 through 18 contemplates when a distributor pays a landowner to dump or receive the material. Could you give me an example of what that might be?
I don't know any real specific examples, but I can imagine instead of taking it to a landfill or to a water treatment facility, they may try to cut costs and pay just a landowner to let them dump it on their property.
And do you further yield?
Yes.
So why would we want to exempt that from the definition of fertilizer?
It's just making it clear that practice is not an agricultural practice, and that's not considered fertilizer.
Thank you, sir.
You have no more questions.
Thank you. I yield the well.
Any other senators wish to speak for or against the motion? The chair hears none. The senator from the 20th has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 512. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the motion, the yeas are 51, the nays are 0, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 512. Will the Secretary read a privileged resolution?
Senate Resolution 530 by Senator Harbin of the 16th and others, a resolution congratulating the winners of the Georgia Civil War Commission Art and Essay Contest and for other purposes. That concludes the order.
Is there objection to adoption of the resolution? Chair hears none, and the resolution is adopted. The Senate will stand at ease for 10 minutes. The Senate will stand at ease for 10 minutes. Thank you.